It's 1:45, and we will reconvene meeting 124. And I guess we are going to Director Day.
Mr. Chairman, the next item is actually the Commission received in response to the Commission's request, really, and concept about the possibility of including a number of gaming positions past one, as in for a slot machine for Penn, as a possible opportunity for the Commonwealth in particular to gain more tax revenue. We asked Penn in particular, but we asked for comment regarding that proposal. In response, Penn sent in a letter, and that letter is in the packets for discussion today. So the concept was is to kind of put that letter back out because the Commission asked, and encourage a discussion from the Commission.
Okay. Who's doing this?
We have a demonstration. That's John back, or
I can do it.
Artem. I'll join Artem over there, and I can just
Okay.
provide some uncapable assistance, and we'll get that rolling.
Great.
Good afternoon, Commissioners.
Good afternoon.
Good afternoon.
So the presentation is to determine how we account for the slot machines in terms of how many gaming positions each slot machine is. So if you go to the first slide, the reason this is important is because Category 2 licensee is capped at 1,250 gaming positions. If you can,
Slot machines.
sorry, it's 1,250 like slot machines. So if you go to the next slide, you'll see the definition of a slot machine. It is a mechanical, electrical, or other device, contrivance, or machine. This doesn't really help too much in determining whether or not each gaming position is one slot machine or not. But you can also continue on to see what a gaming device is. Next slide, please. So a gaming device or gaming equipment is an electronic, electrical, or mechanical contrivance or machine used in connection with gaming or a game. So by these two definitions, it seems that a slot machine is a subset of a gaming device. So every slot machine is a gaming device, but some gaming devices can be something else outside of a slot machine. All right. Continue on to the next slide. Then there's also a question of what is an electronic table game. There's no definition in Chapter 23K, but in our regulations, we state that an electronic table game is a slot machine. This is to clarify that a Category 2 licensee can install electronic table games. And also an electronic table game does seem to fit under the definition of a slot machine. Continue on to the next slide. So now the question is, what is a gaming position? So the definition in Chapter 23K states that a gaming position is a designated seat or standing position where a patron of a gaming establishment can play a game. Now, if you look at a traditional slot machine on the left, you can see that it only has a single player position. But for some electronic table games, they can have multiple positions. The device on top shows that it has 10 positions, and the one at the bottom has 5 positions. Continue to the next slide. So the question now becomes, do you treat those kind of table games with multiple positions as a single slot machine, or as a single slot machine per each gaming position? Continue. So this is just an example of what would happen if you opt for the first definition or for the second. So if you install, for example, 12 devices with 5 gaming positions, then you have 60 gaming positions from that device. If you install 8 table games with 10 positions, then you have 80 gaming positions there. And then if you install 1,110 of the traditional type of slot machine, you have that same number of gaming positions. So in total, you'll have 1,130 devices, but you'll be at the 1,250 gaming position. So if we do choose the first definition for having each slot machine be a single gaming position, then the Category 2 licensee would be capped with this setup. But if we choose the second definition for each device being a single slot machine, then you can see that there is only 1,130 slot machines, and the Category 2 licensee would still be able to install additional devices. Now, these two aren't the only two options. Go on to the next slide. Some jurisdictions have a sliding scale approach where the number of slot machines per electronic table game depends on the number of gaming positions at that table game. So if the table game has between 1 and 5 positions, it'll be counted as a single slot machine. If it has between 6 and 10, it'll be counted as two slot machines. And if it has between 11 and 15 positions, it'll be counted as 3 slot machines. So one more alternative would be to put a cap on the number of gaming positions. So if we treat each table game as a single slot machine, the legislative cap of 1,250 would still apply. But we can also impose an additional regulatory cap of something higher than that amount in order to prevent a scenario where a Category 2 licensee installs a very high number of electronic table games. And one final approach could be to have 2 different periods. So before a Category 1 licensee opens its casino, you can have just the general rule of each table game being counted as a single slot machine. And after the Category 1 opens, there can be an additional regulatory cap at 1,250 or at some other amount. So those are the options for your consideration.
Is there any more guidance in the law that the Penn letter suggests that by not defining gaming positions and slot machines as the same thing, they intended there to be a distinction, which would favor their letter? Is there any other guidance in the legislation or in the history of the legislation on what was going on here? Does anybody know? Did we look into it? No.
Not that I'm aware of.
Not that I'm aware.
And we got no other commentary other than
Well,
that.
no, we don't, nobody looked into that, but it seems to me that when you look at Section 56 and their discussion of gaming positions, that's the tax, sets the tax rate. And they had to take into account both table games and slot. They were taking into account both.
This is the Penn letter?
That's paragraph 2,
Yeah.
where they talk about Section 56, the distinction between gaming positions and not the number of slot machines or tables. That seems to me that maybe they're right, but it also could be just as easily that they were talking about gaming positions to include tables and slots. And the tax on a gaming position would take into account how many people were at a table game, as well as single slot. It just seems to me inconclusive.
Well, I agree with that. That's why I was asking if there's any
I
more.
think
They're citing
what we
it.
don't do is we don't join the two terms in the law. Therefore, it's what they're saying is it's open to your interpretation whether a gaming position in relation to a slot machine is a one-to-one or a one-to-many.
Right.
And that's really how they're looking for you to come down.
And we didn't get any other feedback. Nobody opposed the idea.
Not that I'm aware of that
This is
either.
the only feedback we got, right?
Part, my perspective is that the definition that's in regarding a slot machine actually provides some of a glimpse on that because it doesn't exclude electronic table game. So a lot of my experience has been that electronic table games are identified and defined separately as where the slot machine is one gaming position. Table games, electronic table games are normally more than one. So it seems like to me both of those have been, and the regs, our regs have as well, been combined into the same definition, which I think then moves forward the concept that there could be multiple gaming positions. More than past 1250.
Right. Well, I don't see that anybody gets hurt on this prior to the opening of the other facilities. You know, the only question, it seems to me, is if you count gaming positions as different, and there will end up being more in electronic table games, so you end up more than 1250 gaming positions, whether that is inconsistent with the level playing field for the casinos when they come online. But prior to them coming online, I can't see any downside.
It's interesting that we didn't get any comments, though.
Well, I know, that's,
And I don't know that I think it's fair to allow this and then take it away. As soon as I think people get accustomed to playing certain games, I think it could put Penn at a competitive disadvantage if we were to say you can have it only up until and then take it away. I just, that doesn't seem equitable to me.
well, they'd probably rather have that than not have it at all.
Well, but there could be an in-between where we really do just limit the number that we allow them to have.
First of all, they said that they only expect to have 10 to 15. 10 to 15. And the New Mexico approach struck me as an interesting one, in which they say that multi-station games shall not comprise more than 3% of the total possible allowed gaming machines on the gaming floor. Pens at 10 persons per electronic table game would amount to 2% of the gaming position. So some kind of a approach like that would accommodate their desires, and I don't think would eat into the casino expectations at all.
I would agree.
I would agree with that. And remember, Chairman, there's our legislation, and it was very clear, creates very different economics between the applicants when it comes to what is, some would say, similar games. I could argue it's different. Having an electronic table game and an actual table game may have some similarities. I would argue on the side of there's real differences. And that is 25% versus 49%. At 25%, the casinos have the advantage of getting a lot more in terms of recovering the investment amount. Granted, they have a larger investment amount requirement. But at 51%, the slots parlor is really limited. Whereas we are on the other side. We have the incentive from a finance perspective to have some of these definition, as I've argued in the past, for this.
Yeah. So if they said they would only anticipate, what did you say, 10 to 12?
10 to 15 machines.
And did they imply the number of positions that they would anticipate?
It would be, so 10 would be 100 positions, right? One time.
If it's a
10 would
10
be
seat,
10, well, depending on how many seats, yes.
That's what
I'm
Depending on how
saying.
many seats. So 10 with the 10 and 6 seat games would be 60.
Yeah, but I'm asking whether, did they imply, did they speak to the issue of
I didn't see that.
presumptively how many seats their electronic table games would have?
They did not, right?
But Lance is here, he's shaking his head, they didn't indicate what the size of the table game would be.
I think what's relevant to the, in my opinion, relevant to this, in terms, there's a strategy question. The operator will likely try to figure out and then react to the market as to how many tables, how many 10 4-seat tables or how many 5-seat tables. They'd be able to replace for any one slot machine that fits their business strategy, the marketplace, and frankly, their floor. There's only a limit to what they can do. And allowing some leeway, much like New Mexico does, to say, there's a maximum, there's a cap, whether it's on a percentage basis or in total or in some ratio relative to gaming positions per table game, per slot machines. Either way, I think the operator will likely try to figure out and move within those, within that leeway.
But for our purposes, if hypothetically, we simply said, of the 1,250, 2% could be multiple position games, that'd be 25. And if we hypothesize that the maximum likely at those 25 would be 10 people, that's 250 gaming positions. And that would exceed what they're looking for. And it seems, and increase the yield, and it seems to me 250 more gaming positions wouldn't cut into any reasonable expectation that any Category 1 casino would have. It just isn't going to
Break the bank.
It's not going to break the bank, and it would yield more revenue for us. So it seems to me that, I'm not sure those numbers are right, but it seems to me that kind of an approach is a simple approach, consistent with the statute, and doesn't hurt anybody, and allows some flexibility for the slot parlor operator.
I would
disagree with that. I mean, I think the fact that nobody wrote in and said this is a problem, he speaks, supports what you're saying, so.
If I may, Mr. Chair, members of the commission, I thought I would just mention one point that bears on the point relative to no one commenting yet. This piece is part of the overall slot regulations, which are scheduled for a public hearing on Tuesday, at which point members of the public are invited to come and comment on the proposed slot regulations, including this provision. And it is my understanding that the folks from Penn National are interested in coming and speaking on this issue, in addition to the letter they've already presented. So I would suggest that a final decision on this provision be reserved until that time to allow for any public comment from any further Category 1 applicants or, in fact, Penn National.
I think that's great. In anticipation of that, though, I think we could draft it the way it's suggested here and invite that comment, and invite those comments.
Do we have anything in the draft regulation that talks about a percentage of?
No, we do not at this time.
Right.
So we could certainly draft that language for discussion on Tuesday.
Well, that would be my preference. I would prefer that we incorporate some kind of cap, whether by percent, overall percent, and we let the comment period of the regulations begin. If it hasn't already started.
The
Has
comment
it already
period,
started?
correct, this is the hearing.
This is the hearing, okay.
Correct. So the commission could, from a procedural aspect, draft and vote to include this change as it formally adopts the regulations.
We put it out for public comment many weeks ago and specifically highlighted this
This
issue
provision.
for special comment.
Right.
And this is all we got back.
This is what.
Well, it's pretty arbitrary as to what percent and how many numbers, but your numbers accommodate their aspiration and seem as good as anything else, so.
It's reasonable.
So suggest that we validate Commissioner McHugh's suggested numbers and make the language to reflect something that accommodates the request in the letter. Is that
Put
reasonable?
his suggestion out there as something that we'd like to, that we will be considering, and then we'll come back to it in 2 weeks with whatever other feedback there's been. Yeah, it's hard to see a downside to that, I agree.
Mr. Chairman, with that particular comment, you mentioned, and originally the commission had talked about that being a sunset provision. Is that part of the concept still, or I kind of hear that it would be just a permanent change in the regs
Yes.
at this
Yeah.
point?
That's what Commissioner McHugh is suggesting, yeah.
And 2 others are agreeing.
Yes.
3 others.
3 others? Okay.
Yeah, I wasn't saying we shouldn't do it, I just said the only issue was that possibility that it would change after they come online. And since nobody's concerned about it, then it's not a big deal.
And this may actually have greater surety because it would make a change, but that would be limited to that change. There would be no automatic change again in the future.
Right.
Which I think people may appreciate as well.
All right,
Thank you very much.
Thank you.
Thank you.
so, where are we? Licensing Division. That's it for your agenda? Yes, sir. Director Day?
And thank you, Autumn, for that helpful explanation of the basics.
Mr. Chairman, as our group's collecting here, just let me make a couple introductory remarks with the proposed changes. As the commission will recall, the commission established a gaming vendor secondary license. The idea was to establish a less complex and less expensive, a little less intrusive process for non-gaming vendors. And that's what we're talking about as we approach this discussion today. We have taken a look at that as we've been working with our various applicants. We've come to the conclusion that although we did create another category, less expensive, I'm not sure that we actually made it to our goal of less complex. And so what we're here today is to suggest to the commission, recommend to the commission that we should make some changes through temporary or through emergency regulations to reduce the complexity that we have just in the gaming secondary vendor. And I think we hope to do just a little clarification around the contract, subcontracts that we call as well, giving a little bit more flexibility. So with that, I will gladly refer it over to Loretta.
Good afternoon, Commissioners. As Director Day explained, as we've made our way through the vendor licensing applications connected to the PEN project, we've had the chance to evaluate some of the regs in real time and in real practice, and it's become apparent that some refinement may be in order with respect to the gaming vendor secondaries, in particular construction companies. The existing regs treat a gaming vendor primary, such as a slots company, largely in the same fashion as a gaming vendor secondary. Here, we're again talking about the construction company. Our existing regs call for a highly comprehensive, detailed, and onerous, and for the commission, expensive inquiry into the secondaries. A standard inquiry, which in the view of the IEB and the state police, is not necessary for a thorough background of the gaming vendor secondary. Part of our process in developing the proposed reg to 205 CMR 134, which you have in tab 6 of your packet, was to look at what other gaming jurisdictions across the country do with respect to construction companies. And what we found is that there is no consistent approach of other states to construction companies. Some states do an extremely comprehensive background, some do a more limited background. Some appear to require of executives at the construction companies as in-depth as our key gaming employee forms. Others mere registration with some supplemental questions. With this in mind, we drafted the proposed amendment for your consideration that we feel provide for adequate, appropriate background investigation, keeping in mind two things: the $5,000 fee that the regs now require of the gaming vendor secondaries, and our practice that we do not charge back more to cover the real cost of the investigation to them. And also knowing that we also have in our regulations the ability to call for additional and supplemental information and documents on an as-needed basis as part of the licensing requirements. So turning to the proposed amendments, the proposed amendments do four main things. The first thing is that they say that individual qualifiers for a gaming vendor secondary would have to submit a gaming employee form instead of a key gaming employee form. And the main difference in those forms, as you may recall, is that the key form details the net worth of the individual qualifier and also includes detailed information about family, spouse, children, and some of their financial situation and obligations that may be relevant to the gaming, like the slots primaries, but have limited relevance to the secondaries. So that's one of the areas that we're proposing change. The second area that we're proposing a change in is to for the qualifying entities of the gaming vendor secondary to fill out a BED secondary form instead of a BED primary form. The existing regs actually require the applicant of a gaming vendor secondary to fill out a BED secondary, but the parent and holding companies to fill out a primary, which is lacking in some logic and may in fact have been an error in the regs. The third thing
So the existing reg says that the entity that's going to do the work, that fills out a secondary BED,
correct,
but its parent or a holding company fills out a primary,
correct.
even though they're one step removed.
That's right.
Gotcha. Okay, thanks.
The third thing, as Director Day alluded to, is to make an adjustment in the subcontractor information process. The current process requires that the vendor applicant identify subcontractors up front and continue to keep the commission updated, but also to provide a subcontractor identification form that includes having obtained consent from the subcontractors to fingerprinting and to other background information like Corey checks, credit checks, and so forth. The proposal would require the applicant to identify subcontractors, to keep the commission updated with new subcontractors, but this additional information, including the consent forms, to be required only as an as-needed basis upon request of the IEB.
Would the identification of the subcontractors under the revised reg include an identification of the principals of the subcontractors or just the names of the entities?
At this point, the proposal would be the name of the entity only, and that would be submitted on the BED application form.
Okay.
And the final amendment that we are suggesting is an amendment that essentially states that notwithstanding the forms that are delineated in the regulation, that a qualifier, if authorized by the Bureau, may file licensing information as determined by the Bureau in lieu of the form identified in the regulation. So essentially, if the reg says a BED secondary form is required of a parent or holding company, that the IEB could say, and the example given in the proposed reg is that instead of the BED secondary, for publicly traded companies, copies of their public securities filings and/or audited consolidated financial statements for a period as determined by the Bureau may be filed in lieu of the form identified in the reg. So essentially, those are the four main areas that the proposed amendments cover. Be happy to go through them page by page or try to answer any questions that you may have.
Just to recall, gaming vendor secondary isn't necessarily for vendors who plan to have a long-term relationship with the applicant.
That's correct, and that is one of the differences that the licensing division, the Bureau that we all spoke about, that the primary is somebody who's in the gaming business and is expected to have a long-term relationship with the gaming licensee. But the secondary is a secondary by virtue of a dollar amount threshold that was set in the reg.
Right.
And
What are other examples besides contractors? What are the other categories of likely seconds?
For
Second to
example,
anybody.
people that provide food for the restaurants would be considered, because of the dollar amount, a secondary. So that would be an example of a company, an entity that's long-term, but there may be a company that by a dollar figure may only do it one time, will not be continuous, but be providing a service that's not gaming related, but it's just a one-time service. But food, alcohol are two examples.
A laundry company?
Laundry, linen, garbage pickup, grounds, those type of services.
Director Acosta, knowing, having a background and knowing the history of some subcontractors and issues that have arisen, you're comfortable with this change?
Yes, there's one thing that I think should be mentioned here. We've had discussions in staff that for construction companies, that a memorandum from Director of IAB go out to the construction companies that require them to identify and for the subcontractors to provide identification forms. The subcontractor issue becomes a little bit less clear when you're dealing with a big gaming company. Does the provider of the software to the slot machine, is that a subcontractor? Does that entity need to submit an identification, or should they just be identified? So there are certain subcontractors that we feel should be identified and also provide the form as well. This regulation, the changes give IB and licensing the flexibility to request that form to be completed in certain groups, that is practical, and for certain groups that is not practical, to just simply identify the individuals.
And/or if information is uncovered during investigation or anonymously, however we obtain that information, we do have the ability to go get additional.
The language is quite clear
Yeah.
that IAB does have that authority.
Okay.
What was the reason for not requiring the subs or the applicant to provide the names of the principals of the subs as well as the name of the sub-entity?
On the form currently, they just provide the entity, and the identification form provided the specifics. And this would be just a continuation of that, where on the application that the vendor completes, they identify the entity. If we require them to submit the identification form, all the information of the sub is then at that point provided.
I think it was envisioned that there is ongoing communication about this, and that information would be gleaned in conversations. But the point is well taken in an amendment, adjustment in the BED form to require that as one of the entries. It's, maybe in order.
Let me make sure that we're all on the same page, because the subcontractor or identification form, David, has the listing of each individual, right?
That is correct.
And so what we were doing up until this point, or what we are doing now, is requiring subcontractors that are identified, or requiring that form to come in for everybody. Is that correct?
That is correct.
So the concept here is to, the only change that's made is to have that subcontractor identification form come in at the discretion of IEB rather than with every application. So it's to blend it, to use it for a particular tool where we know there were problems in the past. Building contractors, some of the subs in those areas have been issues in the past, and other areas where we think there's a higher risk of needing that information. So the IEB then has the ability, excuse me, the IEB then has the ability to request that information rather than that burden as we move forward for that all to come in with each one of the applications, which can be quite extensive.
Yeah, got it. I appreciate that. It just, and I don't press the point strongly, it just struck me that the names of people, without even descriptions, might trigger some need for inquiry where the name of the entity as a sub wouldn't. So
I think that's a important point, and we should confirm with state police and IEB that the mere name of the sub company may not give them the initial information that they need to be able to figure out whether to go back and ask for more
Right.
information. So if it's a matter of adding another line on the BED form as to who's the principal of the company,
Or principals, yeah.
or principals, I don't know that that's anything that our information shows that the applicant would have a difficult time or be onerous to the applicant.
But the form is not described in full in the regulations, right?
Not in full.
So that,
So that
there
could be
there could be those kinds of
right.
changes and adjustments, all within the discretion of the IEB, which is the larger point here. And you can modify the form as needed.
But if you don't have the information, you wouldn't know to ask. So
Hence the
it just-
discretion of the...
No, but IEB wouldn't know because they don't have the names to begin with.
Yeah, well, that's my point. The form can be modified without changing the regulation,
To include the names.
to include the name, right.
He's
I
agreeing.
missed your point.
He's agreeing with the, yeah. I agree with it too. I think I agree with everybody else that that's a good idea. The fact that IEB and state police are in favor of this change speaks loudly to me. It's a little counterintuitive to me that we spend millions of dollars investigating these big companies, all of which have been investigated before lots of times with lots of millions of dollars, and are, by everybody's account, by now pretty well cleaned up, these big guys, all the operators, many of them public companies. And where the potential bad guys get in, anecdotally at least, can still get into this business is through the contractual relationships, the very ones you mentioned, the garbage, the construction companies, the laundry, the booze. I mean, those are where organized and unorganized bad guys can try to penetrate an operation like this. So that's where we really are most vulnerable, and we are degrading the degree of investigation at that most vulnerable point of entry. And, as I said, if you guys think it's a good idea, you're in the business, I think I would probably rely on your judgment, but it's a little counterintuitive to me.
I don't think we're degrading it. I wouldn't characterize it that way. There's a lot of flexibility built into these changes, and that's the whole point. Because by requiring everybody to fill out the very extensive forms, there's all these other implications on other things that we also want to balance, like keeping legitimate people away because the licensing process is so onerous. The type of these type of forms that are very lengthy to fill out and can be intimidating to small business, some of the minority businesses, et cetera. So there's a counter argument on the other end as well. So
I think it's a balance between getting information that, to Commissioner Cameron's point, which is giving IEB enough information to be able to go out and start an investigation, then decide whether they need more, as opposed to getting a big,
Presuming it, yeah.
presuming that you need everything.
getting a big data dump of stuff that
Let me
We'll sit and
emphasize
file.
that an entity that is doing business with a casino must either registered or be licensed. What we're referring to in terms of not requiring are subcontractors, which are more common during the construction phase. And by clarifying the definition for the big companies, what constitutes a subcontractor? Do we need to know that Microsoft provided the software for the slot machine to run and have Bill Gates give us an identification form?
I want to see his personal financial disclosure form, if he's willing to
I'm
part
sure
with it.
it'll
I don't
be
think you
interesting to read. But this is what we're trying to accomplish here. So I to your point, I think we are still required by regulation and statute to investigate companies to ensure that we don't get unwanted individuals coming in through the back door.
And I think, Mr. Chair, to address your comment, I think the type of infiltration that occurs with the groups that you spoke to is not revealed in the types of forms that they'd be filling out under the existing regs, and that a different sort of intelligence and investigation would uncover that, which IEB and the state police feel prepared to do in a different manner, and not through the types of information that's gleaned from the forms.
Okay.
I actually like the Microsoft example because if we said that anybody providing anything as a subcontractor would be required to fill out the form, the net effect would be we cannot get that form from Mr. Gates. We were not going to run Microsoft in order to do business here. That's realistically what would happen.
Other questions, thoughts? So is anybody in disagreement with this proposal?
Nope.
No.
And we do need a vote, I guess. Or do we need a vote? Yes.
Yes.
Because we want to adopt this by emergency?
Yeah. Commissioner McHugh?
I would move that the regulations set out, the amendments to the regulations that I'm going to find the beginning of in a minute. The amendments to 205 CMR 134 set out in the meeting packet be adopted by the Commission on an emergency basis, and that simultaneously we move forward with the regular promulgation process, subject to any amendments to the packet materials to deal with the names of principals of subcontractors that we just discussed.
Second?
Second.
Any further discussion? All in favor of the motion, say aye.
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Thank you.
Thank you.
Mr. Chairman, I think Loretta has the next topic.
Okay. We are to item number 7.
And this matter is a request that the commission delegate to the director of the IEB the authority to waive the qualification requirement for institutional investors who own stock in a gaming licensee or a gaming vendor licensee. Under 23K and our regs, the commission may waive the requirement to be licensed as a qualifier for institutional investors holding up to 15% of the stock, of the vendor or the licensee upon a showing that the investor purchased the stock for investment purposes only, does not have any intention to influence or affect the affairs or operations of the gaming vendor or gaming licensee, and that the investor who's granted a waiver, and if the company subsequently determines to influence or affect the affairs, the commission must be notified not less than 30 days before they can influence or affect the affairs, and must submit to qualification. The term institutional investor is defined in 23K, and part of the definition is that the investment company must be registered under the Federal Investment Company Act of 1940. We currently have a company that has invested in Penn National Gaming and has petitioned for a waiver under this section. That company currently owns less than 5% of the stock, but has in the past owned more than 5% of the stock. And based on the statutory terms and our regulations, we have developed a certification form where an employee or officer of such an investment company who has knowledge of the company certifies under the pains and penalties of perjury that he's reviewed the definition of institutional investor in 23K, that the company meets that definition and requires an explanation on the form of how the company meets that definition, that it has no intention of influencing or affecting the affairs of the licensee, and also details the percentages of stock owned by the firm. So with use of the petition process and a certification form as described, signed under the pains and penalties of perjury, I am requesting that you permit the director of the IEB, Director Wells, to grant that waiver in lieu of those investors coming before the entire commission for that waiver to be granted.
Do you foresee, if the director of IEB is doing this, do you see an appeal process by which somebody who's turned down would turn to us?
I think the general appeal process set out in the regs may apply, but I would turn to
Yeah, I mean,
Catherine.
I would think if someone wanted a waiver but didn't receive a waiver, they would come in front of the commission in some sort of a petition process and appeal it. There is an appeal process from decisions of the IEB in general, and so we would first look at that process and use it.
From what you described, an institutional investor holding less than 15%, but having a seat in the board of any one of the companies here, would represent active ownership and control and not apply to the scenarios that you're describing?
I think that company would have a difficult time certifying that they have no control if they had a seat on the board.
Okay.
And I assume there would be some mechanism for reporting back to us each time that this happens, so we know about it.
Yes, we could make that part of the process.
I think
We,
that-
we could do a regular update, as we do with the director of racing on her delegated authority,
Right.
and the executive director as well.
Yeah, I think that would be important.
I see no reason not to approve this request.
I
I
agree
agree.
with that one amendment, yeah. All right, so we need a vote?
Yes, please.
Mr. Chair, I move that the commission delegate the authority to the IEB for determining petitions for waiver of qualifications waiver of qualification by institutional investors.
Second.
And to be reported routinely back to the commission. Any further discussion? All in favor?
Aye.
Opposed? The ayes have it unanimously.
Thank you.
Next.
Finally, is a request that the commission delegate to myself and to General Counsel Catherine Blue the authority to act as hearing officers in racing matters. We're asking for this delegation at this time because Mr. David Murray, who's been serving as a hearing officer on a contract basis, has alerted us that he has conflicts of interest in some upcoming racing hearings that derive from his term as a member of the Racing Commission. General Counsel Blue or I would if this authority is delegated to us, still have to perform an internal assessment to ascertain our independence and unbiased view towards any hearing. But for these reasons, we are seeking a delegation of authority for Catherine Blue and myself to serve as officers on racing matters. And you are authorized to do this under 801 CMR, the rules governing adjudicatory rules of policy and procedure, which define the term presiding officer for such hearings as the individuals authorized by law or designated by the agency to conduct an adjudicatory proceeding.
Do you see this as a temporary thing through a couple of these cases?
I see it as a very infrequent thing. David has one case in front of him where he was actually the attorney representing the Racing Commission, and this now matter is back on an appeal. But generally speaking, David has had very few conflicts going forward. There will also be a point in time in the future when we have more cases where we'll have a permanent hearing officer who will come on board. So that will help
staff
with it
member.
too. A staff,
Yeah.
yes, a staff hearing officer.
Did
So-
I thought you were the hearing officer.
I was.
So,
I did. I served in that capacity until we brought David on board.
okay.
Is it, oh, I'm sorry.
I'm sorry, and the same mechanism of appeal would be preserved, right? Anybody who chooses to appeal the decision of the hearing officer can submit their appeal to the commission.
Yes, as we have before. That's
As we
right.
have.
My question about whether it was a temporary nature is whether it's delegating authority to your position or to you specifically that makes sense.
Under our statute, we have a designation of, the chair can designate hearing officers. Under our statute, it is to a person as opposed to a position. I believe that's how we've read it. I would prefer to do it personally at the moment to Loretta and I because we will watch for conflicts as opposed to a general position delegation, which then makes the conflict check a little bit difficult. But
Is there anything about needing to know anything about the racing business to be a hearing officer?
if we were to put out for a staff hearing officer, we would require knowledge of hearing officer duties. Knowledge of the particular law can be learned, and in David Murray, we're very fortunate because that's the background he comes from. But the more important quality would be someone who would understand the hearing process both under our statute and under our regulations and the 801 CMR regulations as well.
I would,
Done it, so you agree with that?
I do.
Yeah.
I do. When I served in that capacity, DPL had a staff attorney who attended, and I frequently used to make sure we were legally within our rights to do certain things. So no, I see no problem with this at all, and I wish you luck.
I also want to add that the Racing Commission is represented by counsel at all of these hearings, so it's not the hearing officer that is involved in that. We do have Danielle Holmes who represents the commission, and that's basically take the place of the DPL attorney that was there when Commissioner Cameron did it.
Right.
That's the only thing that I wonder about. The entity, the person representing the commission at these hearings is somebody who's subject to the authority of the hearing officer.
It's possible in a case where if I were the hearing officer, that would be true.
Right. How does that work?
We would consider the case carefully before I sat on one. I think I would be more inclined to have Loretta be a hearing officer on a matter before me, unless there was some reason why Loretta couldn't serve. That's why we're asking for an appointment of the two of us.
I've raised that because that's something I was very concerned about from the very beginning. With David Murray, we do have a neutral person there. If we hired a hearing officer, we would wall that person off from normal commission activities, and she would be independent from other commission activities. In some jurisdictions, it's somebody from an outside entity, even though they have an office with the commission. But the appearance of fairness, in this case, knowing the people, it would be the appearance of fairness, is potentially compromise by having an advocate for one of the parties be subject to the direction, control, and supervision of the hearing officer. And one with whom the hearing officer customarily works as a colleague, and so I'm prepared to vote in favor of this, but frankly, I would hope that it'd be a rare occasion when you would actually be the hearing officer. The same problem exists when with respect to either of you, but to a far lesser degree with Ms. Lilios.
And is it true that if there is a situation where that could be a problem, there's always the possibility to come back before the commission to be the hearing commission, right?
That's true. There's also, we could come to the commission to delegate potentially an outside counsel that was neutral
That's
to
right.
do it as well.
Right.
No,
That's
we
right.
could do that too,
Or
particularly
you
in
could
a
have
law.
outside counsel replace Danielle,
That's right.
either way.
Right.
We could.
But
We
I think,
could.
I think even nobody has more experience with appearances than I do. And I think it's a very good point. You know, it's a setup for getting knocked if it ever were to happen. And so I think we ought to make it an amendment to the motion that not happen, and that however it gets adjusted, that there not be a case when the general counsel is the hearing officer, when somebody who reports to the general counsel is the counsel for the commission. So with that adjustment, I think this makes sense.
I would be fine, but this eventuality does happen in many other agencies in the same context, that the attorney is representing a part of, and this is true for DPL, that the attorneys on staff hearing some of the matters, are working with the people that preside over those matters. So I don't think this is, but.
Well, I'm not, quite frankly, concerned with other agencies. Part of the problem with administrative law is that it's viewed as a secondary method and secondary conduit of justice. And I'm concerned, and the reason I raised that concern is that our administrative proceedings not be viewed as a secondary mechanism for doing justice. And so I think our standards ought to not reduce themselves to the least common denominator. That's the reason why I raised that.
Yeah. Any other thoughts? Commissioner Stebbins, you want to try it again?
I defer to the judge on this one.
I don't think there was a motion yet, by the way.
Are we clear? Are we clear on a course of action? I don't think I
Oh,
was.
what I thought we had a consensus was that we would delegate this authority subject to the condition that there not be a situation when the hearing officer is a general counsel and the counsel to the commission reports to her.
Which means we'd be looking for an outside person as a staff attorney, if that,
We might have a staff attorney come in, or we would have perhaps an outside counsel come in and act as the hearing officer
Replace out
if
one
we
or the other.
needed to replace one side or the other.
okay.
And also, this says hearing officers, but it means hearing officers for the racing division, right?
It is just for the
Correct.
racing
Right, so
division,
That
yes.
should probably be in the motion too. Commissioner
Yes.
McHugh, you want to make the motion?
I move that the commission delegate to General Counsel Blue and Counsel Lilios the power to act as hearing officers in racing division hearings, provided that General Counsel Blue does not act as a hearing officer when the commission is represented by a staff attorney under her supervision.
Second.
Second, any further discussion? All in favor?
Aye.
Aye.
Opposed? The ayes have it unanimously. And that may be it.
Thank you.
Anything else? Thank you.
No.
Any new developments, Ombudsman Ziemba, since we saw you last?
I can talk after the meeting, I
No.
think, full commission business.
All right. All right, any other business? Do we have a motion to adjourn?
So moved.
All in favor?
Aye.
All right.